Good afternoon. I'm Kurt Levy, the president of the Committee for Justice. Welcome to the latest in our series of Zoom panels on everything from the Supreme Court and the Constitution to debate over antitrust law and the regulation of big tech. This panel is about calls for Justice Clarence Thomas to recuse himself from cases involving the 2020 election or the events of January 6th. Since Thomas was nominated to the Supreme Court more than 30 years ago now, his critics have periodically alleged that his wife, Ginni Thomas's work for conservative political causes creates a conflict of interest. Those attacks have come and gone, but they've intensified in the wake of recent news that Ginni Thomas encouraged the White House to challenge the 2020 presidential election results in a series of texts to Chief of Staff Mark Meadows shortly after the election. Our panel of Supreme Court experts will examine the calls for Thomas's recusal. And in addition to looking at both sides or all sides of that controversy, we'll look at the law behind it, the history behind it, the politics behind it, and what some of the implications are. And when I say we, I mean our Supreme Court experts, John Malcolm, Russell Wheeler, Mark Paoletta. Should be an interesting discussion because they don't all agree. After they speak, I'll ask them some questions. I'll include some audience questions that come through the Zoom Q&A function or that were emailed to us. So let me introduce the panelists in the order they'll speak. Mark Paoletta is a partner at Sher Jaffe. He served for a decade as the chief counsel for oversight and investigations for the House Energy and Commerce Committee. During the Trump administration, he served as general counsel for the Office of Management and Budget. He also served as a counsel to Vice President Pence. Earlier, as an assistant counsel to President George H.W. Bush, Mark played a key role in the successful confirmation of Justice Clarence Thomas. Mark has a JD from the Georgetown University Law Center. Second, we'll hear from Russell Wheeler. He's a visiting fellow in the Brookings Institution's Governance Studies program. He's also president of the think tank Governance Institute. From 91 to 2005, he was the deputy director of the Federal Judicial Center, which he first joined in 1977. His research and publications deal principally with the federal Article III courts, as well as the immigration courts of the Department of Justice. He's also an adjunct professor at American University's Washington College of Law, and he has a PhD from the University of Chicago. And then last but not least, John Malcolm is at the Heritage Foundation, where he's the vice president of the Institute for Constitutional Governance. He's also the director of the Meese Center for Legal and Judicial Studies. Before joining Heritage 10 years ago, he was general counsel at the U.S. Commission on International Religious Freedom. Before that, he was at the Justice Department. Then he was executive vice president at the Motion Picture Association of America, where he led their worldwide anti-piracy operations, and he's a graduate of Harvard Law. Let me ask Mark to start it off.
There we go. Sorry. Thanks for Kurt, thanks for having us for this panel discussion. And I liked your intro in terms of the attacks on Justice Thomas. This current controversy with respect to Justice Thomas and his wife Ginni Thomas is just the latest smear campaign in a 30-year war on Justice Thomas and his wife. The left hates Justice Thomas because he's a Black conservative who has never bowed to what the left wants and what they think a Black man should think. And in this process, I've actually learned that the left hates Ginni Thomas because she's a principled conservative activist who stands up for her belief and is out there, outspoken in the public square. They're trying to get to Justice Thomas through their attacks on Ginni, but they just hate Ginni for what she represents. Why now? I think that the left is realized that the Supreme Court has a working majority, conservative working majority, and they're concerned that with the upcoming end of the court session and next session, there'll be a number of rulings that will wipe away longtime liberal precedents, and they want to delegitimize the court and attack the justices in advance of that. And that's what's been happening, as you've seen from attacks on Justice Gorsuch and attacks on Justice Barrett. And it sends a signal to them, I think, that this is what awaits you if you maintain your conservative jurisprudence. But they love attacking Justice Thomas. They've been doing it for 30 years. They went after him during his confirmation, and they smeared him and tried to marginalize him when he first went on the court, calling him a lackey of Justice Scalia, false and racist. And so their latest attack, and these attacks on the ethics of the Thomases come around every 10 years. So Justice Thomas went on the court in 91. I think the first real attack on Ginni Thomas and her work was in 2000 when she was working with the Heritage Foundation. And I just want to sort of back up and talk a little bit about what Ginni Thomas does so people understand. Ginni Thomas is what she does and why this controversy is here. She's a longtime conservative activist who's been doing this work for her entire life. Her mom was a delegate for Reagan in 1968, and she got her political passion from her mom. And she's worked for Hal Dobbs. She's worked for the Chamber of Commerce. She's worked for Dick Armey up in Congress when he was majority leader. She's worked at Heritage and Hillsdale. And she's just been somebody who's been in the public square pushing conservative policies. And she was doing that long before, as I said, she met Justice Thomas. And I think when Justice Thomas became a judge and then a justice, she didn't think she should have to give up her career. And in fact, there are hundreds of judges who have spouses at the state, local, and federal level, who have spouses who are in elective office, who are in public policy positions, that are in the public square. And nobody seems to criticize them. In fact, they're celebrated. But for Ginni Thomas and for the left, with respect to Ginni Thomas's work, it's a problem that she doesn't sort of leave politics and get in the kitchen. I call it feminism 2022, where this is there are a lot of spouses who do what Ginni does, but somehow she's got a problem, and they attack her, and in a way want to get to her husband. So the first attack on Ginni was in 2000. She was working for Heritage, and she had worked for Dick Armey. She had done oversight work in the majority leader's office, and so she wrote to the oversight committees in the Senate and House asking if there were staffers who wanted to come into the new administration. She was at Heritage. It wasn't on behalf of the Bush campaign. It was just send resumes into Heritage if you're interested in working in the administration. This was during the time of the Bush v. Gore litigation. And critics said that Justice Thomas couldn't rule on Bush v. Gore because Ginni Thomas had this interest, this so-called interest in Bush being elected so that these people can go into the administration. A baseless attack. Justice Thomas didn't recuse himself, but that's been one of the core elements of the Thomas kind of transgressions, is this going back to 2000 when Ginni was working at Heritage and taking resumes from people who wanted to work in the new administration. The next attack came, I think, in 2011 when members of Congress called on Justice Thomas to recuse himself from the Obamacare rulings because Ginni had criticized the Obamacare law, calling it a disaster and urging its repeal from Congress, not from the court. And so, again, because of these statements, the critics asked Justice Thomas to recuse himself from ruling on that case. It's interesting to note that the very ethical member of Congress who led that charge was Anthony Weiner, who around that same time, his other activities came to light, and he resigned shortly thereafter. But again, an attack on Justice Thomas and his wife because of Ginni's activities. Again, my view, no basis for Justice Thomas to recuse. And that brings us up to the current time period where Ginni Thomas, again, when she left, I guess it was her Heritage and Hillsdale, she formed her own company that was kind of a consulting company to help conservative groups and work with conservative groups and leaders to kind of connect up and amplify their message and push certain issues in I call it the public square. And so they'd write to members of Congress, they'd write to the administration, they'd issue these public letters on issues. And so during the Trump administration, she worked with these groups of people, and she worked with the Trump administration. And there, in terms of the ethics charges against Ginni and Justice Thomas, she was involved with some groups. One of them, she was on an outside advisory board, non-paid. And it was, again, for this amplification, nothing to do with legal work. Ginni doesn't do any legal work. She's never practiced law. She has a JD, but she's never practiced law. She's never filed a brief. She never worked on a brief, that sort of thing. When she gets hired by these groups or works with these groups, it's on amplification and I'll call, sort of coalition building to build their message, amplify their message. And so she was with one group, National Association of Scholars, as an outside board member, advisory board member, non-paid. That group, unbeknownst to her, filed an amicus brief in the Supreme Court on the Harvard case, the Harvard admissions case. And again, critics are now saying that Justice Thomas should recuse because of this amicus brief, which Ginni had nothing to do with, was not paid for. And again, Russell or John can address the standards there. But again, that's one of the charges against the Thomases. The second one, in terms of groups, is she was an outside consultant for a group that filed an amicus brief. Again, she had nothing to do with it, wasn't paid for that. She's paid for other work, an amicus brief on the President Trump's travel ban. And again, the critics say that Justice Thomas should have recused from that. There's no basis for a recusal, but that's the charge. The latest criticism is that Ginni Thomas sent text messages. She was a supporter of President Trump. She was actually an elected delegate from Virginia during the 2020 campaign for President Trump. She was supporting him for his reelection. And after the election, she sent, shortly after the election, she sent a number of texts to the then Chief of Staff, Mark Meadows, expressing concerns about fraud in the election and urging them to sort of go to court and fight for their concerns about this fraud. Now, that's basically what every single election lawyer or advocate does in the past 20 years. If you look at elections and people have concerns about fraud, and people go to court to address those concerns. That's what she did. That's all she did. Lots of people have concerns about fraud in the election, and lots of people go to court to explore their, enforce their concerns. Because of those text messages and her concerns, the left has now said that Justice Thomas, can't do any cases, can't send out any cases with respect to the 2020 election. And then specifically, there's a case he sat on where there was President Biden had the J6 committee had subpoenaed documents from the from the Trump White House, internal White House documents, and President Biden had waived executive privilege on those documents and wanted to give them to the committee. President Trump, former President Trump, challenged that and went up to the Supreme Court, asking the court to review sort of the legality of that, the constitutional legality of whether he has any rights to those documents. Justice Thomas sat on that case, was the lone dissenter, and the critics have now said that he was obviously trying to cover up for Ginni Thomas's texts, that they were in these documents. That's utterly absurd because those documents concern internal White House documents and executive privilege. Executive privilege only applies to communication between the president and his aides and advisors. So Ginni never worked in the White House. She's not an aide to the president. So by their very terms, these documents don't concern her records. So there are serious issues as to why there might be concerns about the waiver here. And there's been some articles in the past couple weeks that have addressed that. But that is what has led us to this panel, I think, is that critics think that Justice Thomas shouldn't be sitting on the cases with respect to the 2020 election or with respect to the J6 activities and any law, cases that come up to the court on that issue.
Thank you, Mark. Russell, let's hear your thoughts.
Well, thanks for the invitation to join the group, Kurt. It's good to be with all of you. You asked me to talk a little bit about the laws and other regulations governing the ethics of Supreme Court justices, which is a topic of gross misunderstanding on the major editorial pages of the country and members of Congress and others. And in 7 or 8 minutes, I'm not going to be able to nail it all down, but I'll try to cover some of the basics. It is certainly not true to say that justices, unlike other federal judges, live in a world of unregulated judicial ethics. They are covered, for example, by the Ethics in Government Act, requiring financial disclosure and limitations on gifts. The key statute here, though, is Section 455 of Title 28, the Judicial Disqualification Statute, which applies by its terms to justices, judges, Court of Appeals judges, district judges, magistrate and bankruptcy judges, and others. And basically, it has two provisions. It tells judges that they should recuse themselves, a quote from the statute here, in any proceeding in which his, still says his, in which his impartiality might reasonably be questioned. And then it itemizes in Section B a variety of specific instances in which recusal is required, such as prior involvement in the case, or a financial interest that the judge may have in the case, or that the judge's spouse or children may have. The important thing to understand about the statute is that the recusal decision is a judicial decision. It's not an extrajudicial decision. It is a decision on the merits. And there is a substantial body of case law that's been built up by decisions of the courts of appeals and the Supreme Court interpreting the judicial disqualification statute. Now, as a decision subject to appeal, of course, there is no judicial court higher than the Supreme Court. So while other judges' recusal decisions, failure to recuse when a motion is filed, I should say, are subject to appellate review, there's no appellate court to review decisions of the Supreme Court justices to decline a recusal motion. And I should emphasize, I should have said before, judges obviously can recuse in two ways. They can recuse sua sponte and just say, I want to take myself off this case because I have an involvement with it. Or they can recuse or not recuse in response to a specific motion. Obviously, the former kind of decision is not subject to appeal. The latter one is, but in any case, the Supreme Court justices' decisions are not subject to appeal. Now, there have been various proposals to change that. There's a Senate Bill 4010, Senator Whitehouse has introduced, would, for example, require a justice who receives a recusal motion either to grant it or refer the matter to the entire court. That is very similar to the Texas Rule of Appellate Procedure 16, which requires the same thing. From what I'm told, people in Texas, it works fairly well. Now, there's another statute which does not apply to the justices, which allows anybody to file a judicial misconduct complaint with the chief judge of the circuit, alleging that the judge is engaged in what the statute calls conduct prejudicial to the effective and expeditious administration of the business of the courts. There are about 1,000 complaints filed per year. Almost all of them are dismissed, and having looked at some of them, rightly so. But the point is, even if that statute applied to the Supreme Court justices, it wouldn't reach recusal decisions because, as I said, recusal decisions, as spelled out specifically in the conference's rules for administering the statute, are merits decisions, and the statute does not reach merits decisions. There is finally the Code of Conduct, which the Judicial Conference has issued for judges under its jurisdiction, which does not include the Supreme Court justices. It is contrary to what a lot of people say, it's an aspirational set of guidelines. It's not a binding code. There is some confusion, though, because the code repeats the disqualification statute almost verbatim. So someone could be understandably could look at the code without being aware of the statute and think somehow or other it governs, but it doesn't. Now, recusals at the Supreme Court level are relatively rare. The President's Commission totaled them up for the years 2015 through the last term, and they ranged at the merit stage anyway in the range of maybe 1 to 6 recusals a year. Many more at the certiorari stage, because there are a lot more certiorari petitions than there are merits decisions. I did a similar study for the years 2008 through 2012 and found about the same thing, except the years 2009 and 10, when recusals shot up because of Justice Sotomayor and service on the Court of Appeals with the Second Circuit, and then, of course, Justice Kagan's service as Solicitor General. I only found 2 instances, though, in all those years in which a recusal created a 4-to-4 split on the court, which of course, basically negates the litigation and leaves the court decision below in place. Now, some groups, mainly on the left, who think the court's ethics are too lax, have identified, by my count, maybe 15 or 20 cases in which they say justices should have recused when they did not. I haven't looked at each one of those in detail to know what merit those complaints may have, but even at that number, it's not a terribly high number. There have been some interesting recusal decisions in the past several decades. Associate Justice Rehnquist declined to recuse in a case called Laird v. Tatum because of some contact he had with those issues, national security issues, as an assistant attorney general. He explained why he was not going to recuse. Justice Scalia was asked to recuse in a case involving the phrase "under God and the Constitution" because he had given a speech in which he said he didn't think those were matters to be settled in a democracy, to be settled in court. And Justice Scalia indeed did recuse himself. He also asked to recuse himself in a case involving a committee that Vice President Cheney chaired because Scalia had gone on a duck hunting trip with Cheney to Louisiana. He didn't explain why he refused to recuse for several weeks. When he finally did, I think most of it looked at it and said, well, there's no reason he should have recused, but why did he wait so long to tell us? Which says something about the value of transparency. Then, of course, as Mark said, in 2011, there were calls for Justice Thomas to recuse in the Affordable Care Act litigation, and similar calls for Justice Kagan to recuse because as Solicitor General, she may have had some contact with the cases, administration's position as the case was being developed. There were no motions for either one of them to recuse, as far as I'm aware anyway, and neither one of them did. And I think in both cases, those calls were tactical. They were an effort to get Kagan off the case and an effort to get Thomas off the case. So that's where we stand. I've taken almost 8 minutes, so I'll drop it at that and I'll try to answer questions later.
Okay, I guess.
Thank you, Russell. And last but not least, John.
Thank you. Well, it's a pleasure to be with you. So I've been asked in my remarks, which may run a little bit more than 8 minutes, 3 topics. One is whether Justice Thomas's recusal from the January 6th cases that may come before the court of the 2020 election is required or advisable. The second is the politics behind the current controversy. And the third is the implications for imposing a judicial code of conduct on the Supreme Court. With respect to the first issue about whether Justice Thomas's recusal is somehow required or advisable, I think the answer is an emphatic no. So Ginni Thomas is a longtime conservative activist. So what? Having personal views on politics, on political issues, is not a disqualifying event, even for the Supreme Court justices themselves. We have had Supreme Court justices, many of them, who held political office, identified with one political party or another, before joining the court, including a former president, former presidential contenders, former senators, and former governors. They certainly had political views, and they certainly heard cases that had political overtones. Nobody ever thought to ask them to recuse themselves because they thought that they would not be able to set aside their political views and rule in an impartial manner. Ginni Thomas does not get her constitutional rights, including her right to free speech and freedom of association, from her husband, and she does not dictate how he should decide legal issues that come before the Supreme Court. She informed the Washington Free Beacon several years ago. She said, quote, "Clarence doesn't discuss his work with me, and I don't involve him in my work, and there is no reason to doubt her word or his word that they stick to that." Mark said, although Ginni Thomas has a law degree, she is not now, nor has she ever been a practicing lawyer. She is not a litigant in any of these cases, nor is she affiliated with any organization that litigates any of these cases. She wasn't inside the Capitol on January the 6th. It doesn't have any financial interest in the outcome of any 2020 election dispute or January 6th related case. And there's, of course, no credible evidence whatsoever that she could face any legal jeopardy as a result of what happened on January 6th. So Russell talked about how federal law prohibits a judge from hearing a case if their spouses have, quote unquote, an interest that could be substantially affected by the outcome of the proceeding. And an interest for the spouse of the judge has, according to longstanding practice, means that their income could be substantially affected by the outcome of the case. If they are a lawyer or litigant in the case, or a potential witness in the case. Ginni Thomas is none of them. The fact that you may have a spouse that cares passionately about a legal issue and wants an outcome to come out a particular way is not a disqualifying interest. If that were the case, for example, any male judge who had a wife at home who was either passionately pro-life or pro-abortion, that judge would have to recuse themselves because his wife would have an interest in the outcome of a case. Caring about how a case comes out is not a disqualifying interest. The other ethical rules, which Russell also quoted, said that a judge shall disqualify himself in any case in which his impartiality might reasonably be questioned. Ginni Thomas's messages back and forth with Mark Meadows, they may have been unwise, they may have been hyperbolic, but there is no reason whatsoever to question Justice Thomas's integrity or his impartiality. The messages didn't contain any legal analysis whatsoever. Really what they did was they reported rumors that were flying around at the time of the election and urged President Trump to keep fighting. These are completely disconnected from the arcane but important legal issues that were involved in cases that Justice Thomas has considered, such as whether the elections clause applies to last-minute changes that were made to state voting laws, or whether executive privilege applies to the release of some of these messages. They are divorced from any of the messages that Ginni Thomas shared with Mark Meadows. Russell pointed out that, if you're on a lower court and you recuse yourself, you can be replaced. Supreme Court justices do not have that luxury. And Supreme Court justices have long recognized what they refer to as a duty to sit, since if they don't sit, it can result in a 4-4 tie. Justices are not supposed to recuse themselves on the basis of any speculation or wild conjecture that may be promulgated by liberal advocacy groups or left-leaning media. Justices recuse themselves or not based on hard facts and the reasonable inferences that can be drawn from them. Justice Thomas knows how to recuse himself. He has done it by recent reports 32 times over the course of his career. He recused himself in a case involving a college that his son was attending at the time. He recused himself in several cases involving the Wachovia Bank at a time when his son worked there. There's no reason for him to recuse himself in these cases. So second, what's the politics behind this current controversy? Well, Mark alluded to this. This has been part of an ongoing campaign to intimidate conservative-leaning judges to rule the way that the left wants, or else to make them aware that they are going to face an onslaught of criticism. This is not new, but it's getting worse. So you had Senate Majority Leader, at the time Minority Leader, Chuck Schumer, standing on the Supreme Court steps as an abortion case out of Louisiana was about to be argued. And he shouted out, he goes, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you if you go forward with these decisions." Senator Sheldon Whitehouse recently filed an amicus curiae brief on behalf of himself and 5 of his Democratic colleagues in a Second Amendment case. In that brief, he said that the Supreme Court was not well, and that if it did not heal itself, it might have to be restructured, which everybody understood is code for court packing. This has been, as Mark clearly laid out, part of a 30-year effort to denigrate Justice Thomas and to suggest that his involvement on the court is somehow illegitimate or will taint any decisions that the court has made. Liberals have demanded, for instance, that Justice Thomas recuse himself from all cases involving the Biden administration because of how then Senator Biden treated him during his confirmation hearing. That is absurd. Cory Booker demanded that Brett Kavanaugh recuse himself from all cases involving alleged scandals with former President Trump. I don't recall any Republicans demanding or any Democrats suggesting, for instance, that Justices Breyer or Ginsburg should recuse themselves in cases involving potential scandals involving Bill Clinton, although, as we know, there were plenty of those. The left was completely absent when Ruth Bader Ginsburg participated in cases involving the Trump administration after she told Adam Liptak of the New York Times prior to the 2016 election. I can't imagine what this place would be, meaning the Supreme Court. I can't imagine what the country would be with Donald Trump as our president. For the country, it would be 4 years. For the court, it would be, I don't even want to contemplate that. Now it's time for us to move to New Zealand. She even called former President Trump a faker and criticized him because he failed to disclose his tax returns. She then sat on lots of cases involving the Trump administration, including a case about whether or not President Trump should be required to disclose his tax returns. The left was again absent when Justice Ginsburg sat on cases after her daughter, Jane Ginsburg, who's a prominent law professor, had written articles expressing her views on pending cases and which ways they ought to come out. She sat on a case involving a company whose founder and owner had endowed a chair in her husband's name at Georgetown Law School. She sat on cases involving the now Legal Defense Fund, even though she had served on that organization's board for years and had donated a signed copy of her VMI opinion, which they auctioned off at a fundraising event. The left was absent when, as Russell said, Elena Kagan did not recuse herself from the Obamacare cases, even though she was Solicitor General when the law passed, and even though she was involved in initial discussions about how to, how to present legal arguments to defend the law. The left has been absent when DC Circuit Judge Nina Pollard, she's married to David Cole, who's the ACLU's National Legal Director. She has voted in at least a couple of cases in which David Cole published articles talking about the cases and saying which way the cases ought to come out. And of course, there was Ninth Circuit Judge Stephen Reinhart, probably the most overturned judge in circuit court history. His wife, Ramona Ripston, was the executive director of the ACLU of Southern California. He sat in a same-sex marriage case in which he'd made public comments about the case and had even filed an amicus brief in the lower court. This is the same judge who once said that ruling in constitutional cases involves value judgments. And he was asked, about being one of the most overturned judges in history. He said, well, quote unquote, they can't catch them all. Finally, the implications of imposing judicial ethics standards on Supreme Court justices. Well, for one, there's I happen to think that this is largely a solution in search of a problem. There are, however, serious constitutional separation of powers concerns about Congress applying a code of conduct to the Supreme Court. The first sentence of Article 3 says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So the Supreme Court has its own source of constitutional authority that is separate apart from the political branches. Although since Congress can establish lower courts, they have some authority over those lower courts. I don't think that Congress could impose a code of conduct on the Supreme Court any more than the Supreme Court can impose a code of conduct on them. Moreover, the reason I say that this is a solution in search of a problem is that the judiciary has actually been fairly responsive when legitimate concerns about sexual harassment or an insufficient attention to financial holdings when cases are assigned to judges. They've been pretty responsive when those problems have arisen. The justices have said for the most part, they voluntarily comply with the code of conduct. There's no reason to think that they don't. And although the complaints about the court are that it is not a transparent body, it is in fact far more transparent than either Congress or the executive branch. All the briefs are filed with the court and are publicly available. There are audio versions of oral arguments shortly after they take place. They issue written opinions in all merits cases and in other cases involving the so-called shadow docket. Good luck walking into a congressional office or into the White House and asking to partake in meetings in which classified information and whatnot is discussed. In short, the justices, when they recuse themselves, it's pretty obvious why they recuse themselves. When they don't, it's obvious because they didn't think they needed to. And I don't think that requiring justices to give further explanations is going to add anything of value to any particular case. And it certainly won't tamp down any criticism, as evidenced, for example, by the fact that Justice Thomas has said nothing about the current controversy. He hasn't recused or not recused from any particular case. It has not stopped the left from piling on. So with that, I guess I will stop, and I look forward to everyone's questions.
Thank you, John. Before we get into questions, let me ask John, Russell, and Mark, are there any remarks by your fellow panelists that you wanted to respond to?
Mark, you're muted.
Mark is muted here.
Gotcha. Yeah, great presentations, John and Russell. You know, to me, it's such gaslighting that's going on right now. In terms of John talking about some of these examples, you know, we talk about Stephen Reinhardt and his, and again, his wife was the executive director of the ACLU Southern California, filed a brief below, had spoken out very prominently on this, the issue before the court at the time, a same-sex marriage ban in California. And you had these, what I found interesting is there are these judicial ethics experts, Stephen Gillers in particular, who came in support of Judge Reinhardt and filed this brief that anyone who questioned the idea that, you know, Ramona Ripston, his wife's views had any impact on Judge Reinhardt was sort of a sexist pig and living in the old centuries. And so fast forward to the Ginni Thomas example, and who do you have trashing Ginni Thomas for commenting on things and Justice Thomas sort of sitting on cases? Stephen Gillers. And I just find the politicization, the weaponization that we see so much with experts who don't have, in my view, any principles, are completely political and are deployed. So I encourage your viewers to read Reinhardt's opinion defending his decision to not recuse, and then also Stephen Giller's brief. This went up to the Supreme Court on an amicus level, and there was some conservatives seeking Reinhardt and the judge below's recusal, that this was reversible error for that, and Giller's filing an amicus brief defending Judge Reinhardt's decision. So again, my view, the standard that is being applied to Justice Thomas and his wife has no place in the law, as Russell's laid out, I think, and John, and in practice, in precedent, as John's laid out. And so it's just a double standard, and even with judicial ethics experts, it's a double standard.
Any other responses?
Yeah, I have a few. One thing I think, there's no doubt, nobody would argue that having a wife who's engaged in, heavily engaged in political activity is judicial misconduct. I might even say somewhat outlandish activity. I disagree with my panelists somewhat on her activity, but I think that what we're talking about here in this ethics regulation is balancing, on the one hand, the need for judges to be and appear impartial and to help them do so. And on the other hand, not be so constraining that judges, nobody wants to be a judge because they have to live as hermits. There is an admonition in the codes of conduct in a commentary to Canon 2A, which I think bears repeating. And I think maybe in this day and age, maybe even some extension. The code says, this is advisory, a judge must expect to be the subject of constant public scrutiny and accept freely and willingly restrictions that might be viewed as burdensome by the ordinary citizen. And I think that's no doubt true. In this day and age in which, as others have pointed out, spouses of judges, husbands and wives, and as well as domestic partners are more and more engaged in politics, we should welcome that, no doubt. Rejecting the view that the only role for a woman is to sit home and bake cookies. On the other hand, we may be reaching the point where spouses have to accept some of the kind of limitations that the canon, the code suggests that the judges will have to accept. If you want to be a judge, you have to accept the fact that you can't do some of the things that you would do, as they say, as an ordinary citizen. That's point one. Point two, I don't disagree at all that most of the attacks on Justice Thomas are tactical. They don't like him and they want him off as many cases as they can. I accept that. I think that's true. I think it's also true that judges on all sides of the political spectrum, or the ideological spectrum, have engaged in some behavior that we wish they hadn't. So, no argument there. My concern, however, is the court as a whole. Two comments. One is whether or not it would be constitutional to have Congress require the court to adopt a code. I don't really much care. I think I can't understand for the life of me why the court doesn't adopt its own code of advisory ethics, just as a statement that we take this stuff seriously. It's not going to change behavior an awful lot, but it's more than just a superficial action. And I and many other people on all sides of the spectrum just wonder why the court won't do it. Justice Kagan said a couple of years ago that they were considering it, but we've heard nothing about that since. I don't understand. It seems to me the court, from a practical standpoint, we want to put it behind it by adopting a code, but that's neither here nor there. I am concerned about the legitimacy of the code of the court and its perceptions that people have of it. I'm not worried about the 1/3 of the country who think the court is a terrific institution, or the 1/3 who are convinced that it's the devil incarnate. Talking about people in the middle, parts of the informed public, who see a court, most of whose members were appointed by presidents who did not enter office with the majority of the popular vote, especially 3 who ended by a president who massively lost the popular vote, including one who was appointed at the time that president was being voted out of office. And the resulting decisions of the court, which they say do not reflect the views of the majority of the American people. And now I realize the court is not engaged it should not be engaged in a popularity contest. But my old boss, Chief Justice Rehnquist, was right when he said you have to put the court needs a popular imprint on it. You get that by presidential elections and appointments. I think the court is in a bit of trouble. And I don't think, frankly, that what Justice Thomas's wife has been doing, put aside whether or not they talk to each other about it, I'll take their word for it that they don't, are creating an appearance of impartiality that I don't think this court can stand. So much for that.
If I could jump in, I have 3 very quick things to say. One is, there are clear lines. Judge Alice Batchelder of the Sixth Circuit, her husband just passed away, but he was the longtime Speaker of the House. Right. In Ohio, we had Margie Rendell on the Third Circuit. Her husband, Ed Rendell, was, mayor and then governor, and he was the head of the DNCC. So there were clear lines about when you could recuse. The justices on the court have said that for the most part, no reason to believe there are any particular exceptions, are going to abide by the code of conduct. If they were to put something in place, as you suggest, who would oversee the decisions made by the individual justices in particular cases? Congress isn't going to do it. His fellow justices are not going to go behind closed doors and take a vote to apply a particular canon to a justice and force them to recuse. So I just don't see that as being an adequate solution, even if they did it. And with respect to justices who are appointed by presidents who didn't get a majority of the popular vote. The president whom we revere probably among the top 2 or 3, Abe Lincoln, was nowhere near having a majority of the popular vote. And certainly nobody has said anything at all ever against Ruth Bader Ginsburg or Stephen Breyer, even though because of third-party candidates, both elections that Bill Clinton won, he won with less than a majority of the popular vote. So we have the system that we have. It's an electoral process. It has, almost all the time, with a few very notable exceptions, and particularly recently, the winner of the Electoral College also wins a popular vote. But we have gotten by just fine when justices have been appointed by presidents who did not, in fact, garner a majority of the popular vote.
Well, we can get into specific details, for example, about the Clinton election and whether or not all those Ross Perot votes would have gone for Clinton or his opponent. But I don't want to get
it doesn't matter.
No, just at the end of the day, because there was a third-party candidate, right, he got less than 50%. I mean, if you posit any election in which there are more than 2 people, and the winner doesn't get a majority, you can speculate about where the votes would have gone, but it is what it is.
Right. Yeah.
And Russell, I just want to make sure that I understood what you said. Were you saying that the calls for Thomas to recuse are tactical or aren't tactical?
I think a lot of them. I think a lot of it is tactical. I mean, it was surely the calls in 2011 for Thomas and Kagan to get off the Obamacare litigation. There's no doubt that was tactical. And I think part of it is, of course, I mean, Mark's exactly right. The liberals have not liked Justice Thomas since his confirmation hearings. There's no doubt about that. for the largely, I think, for the reasons he mentioned. So there was that added to it. They haven't liked Justice Ginsburg either for a lot of reasons. And I think she was tone deaf in many instances by her refusal to get off cases. I mean, there's plenty of blame to go around here. I just think the justices, my sense is the justices have adopted the view that kind of it's our court and we'll do what we want with it. And I think they're heading for trouble with that attitude.
Although Justice Ginsburg, who had been a prominent lawyer with the ACLU and a liberal activist as an advocate, was confirmed with well over 90 votes. Clarence Thomas was confirmed 52 to 48.
And Antonin Scalia was confirmed unanimously.
Those days are gone.
So a couple of things. One is there is a statement of recusal policy, right, that the court adopted in 1993, right,
Yeah.
which is their interpretation of 455, which does, as you said, Russell, apply to the Supreme Court justices. So I do think that and it's important, and for the viewers, essentially, so long as because they issued it in 93, 7 justices from Stevens to Ginsburg, Thomas, everyone except I think Souter and Blackmun signed it, applying 455.
And then Roberts said after he was confirmed that he would apply to it also.
Okay, and so again, it is an effort to apply it and be governed by it, and so again, and what's important there to me is that even if your family member, a son, daughter, wife, is involved with a case below, at the district court level or the appellate level, if they're not the lead lawyer, right? If they don't appear before the Supreme Court, that justice can sit on the case. So if you think of the Ginni Thomas's kind of the arguments against Ginni Thomas that the left is throwing out there, and you take that, she's not even involved in any case, and she's made comments, and the Supreme Court justices have a rule that's interpreting. They're the Supreme Court. They're interpreting 455 and what it means. That's what they do in this memo. Is that if you're below, if you've literally litigated at the court below, there's no problem in terms of the appearance for the justice to sit on that case. The second thing, I guess, is yes, in terms of the tactical nature, I think they had asked for Kagan to recuse back in 2011 because of her time in the Solicitor General's office, and then the letter came to Justice Thomas to recuse. My only complaint is this is being used. Nobody ever talked about impeaching Justice Kagan, okay, for not recusing herself, right? Michael Tomasky from the New Republic and other journalists now and on the, I think up in Congress, are actually saying Justice Thomas should be impeached. Okay, one of the articles of impeachment is because he didn't recuse himself on the Obamacare case. Okay, so it's this level of hatred. It's not just a tactical thing with Justice Thomas in terms of the left. They did that, but it continues on. And the sort of the gaslighting, as I said, I have here, and I won't go through it, but me, and I support all of this. I want to make sure people understand. When you have a spouse in the public square, I'm completely fine with it. What I don't like, and I object to vociferously, is the double standard for the Thomases. So Nina Pollard is a judge on the DC circuit, okay, an Obama appointee, okay, very liberal, okay. Her husband is David Cole. He is the legal director for the ACLU. If you go on his Twitter feed, okay, he addresses a lot of issues in a very partisan way, attacking President Trump on issue after issue after issue, okay. Now, I don't see anyone bothered, Russell. I've never seen an article about David Cole, except for maybe mine, raising issues about him, talking in the public square and creating problems for his wife and whether she should be sitting on various cases with respect to the Trump administration. Because if you read David Cole's comments, they are pretty hard on President Trump on issues and on character. And she's a DC circuit judge, right? That is the feeder into the Supreme Court. It's the same standard these judges get as high profile cases, not the Supreme Court, but it's the same issue. And nobody has a problem with it. We had this with Reinhardt. So you say that Ginni Thomas's conduct creates a problem. It only creates a problem because the media and the left has decided it's a problem when you can point to issue after issue after issue, or example after example of other spouses of judges at the lower court. And even I'd say, again, we've talked about the Ginsburg one. Her husband was at a law firm, right? Jane Mayer in her piece doesn't want to deal with Ruth Bader Ginsburg and Marty Ginsburg. So she tells her reader that Marty Ginsburg left his law firm and went into teaching when Ruth Bader Ginsburg joined the DC circuit and then went up to the Supreme Court. That's completely false. He practiced law. He came down here. He joined a law firm. His firm appeared before the Supreme Court many, many times. And Justice Ginsburg voted in favor of Marty Ginsburg's colleague's client. But nobody raised an issue about that.
I'm not here as an advocate for double standards. I'm really not.
Right.
I think the rule of reason that I lifted out of and suggested extending out of the code of conduct commentary should apply to all judges. I think we're in a new era now in which, because spouses are now politically active, and we're glad they are, I think we may have to just look again at this argument that they don't lose their judges, spouses, and kids don't lose their First Amendment rights once their husband or father or mother goes on the bench. As a general principle, yeah, but I think we can't be bound to this earlier view we had that there's just simply no problem with it. I think there are problems with it. The ones you've mentioned, I think Justice Thomas's wife creates a problem for the court. I really do. And I'm not worried about, the exuberant liberals. I'm worried about the people in the middle. We want the court to be respected by people who don't think about this stuff every day. And I think that's in jeopardy for a variety of reasons. And I don't know Justice Thomas well. The contact I've had with him, I've never found anybody more gracious and unassuming. And I presume his wife is that way also. But I just think there's a problem there. I really do.
Yeah, but if you allow a heckler's veto to determine whether a judge is going to recuse or not, that also will delegitimize the court. And that's, I think, what's going on now. The reason you see it's an appearance problem is because the left is screaming that it's an appearance problem, even though if you look at the facts themselves or any reasonable past precedent, it's not.
Well, Mark, you mentioned impeachment. Is there any precedent for federal judges being impeached or resigning because of this type of conflict of interest? This is a question for all of you.
Yeah, I'm not aware of. I'm sorry, go ahead, Russell.
I was going to say, well, Justice Douglas, then Representative Ford wanted to impeach Justice Douglas. Wasn't so much for the activities of his wife as it was for his activities. I haven't heard much more of that. And I've heard calls for impeach Justice Sotomayor. That's not been unheard of.
Yeah, but you're not hearing senators and congressmen who are now calling for this. I mean, look, there have been judges.
No, and I think it's silly to call for Justice Thomas's impeachment.
There are judges that have been impeached and thrown off the bench. It is almost always because they committed a crime, taking bribes, tax evasion, standard stuff that trips up people. I think in the very early days of our republic, obviously, Samuel Chase was impeached during the Jefferson administration because he was rude to litigants and he was an ardent Federalist. And even with an overwhelming majority in the Senate that Jefferson's party had, they acquitted him. And I think there was one judge who was thrown off because he was such an inveterate alcoholic that he could no longer sit on cases. So clearly he did not have good behavior. But I think there's certainly never been anybody impeached for, something like this.
Well, I think we have agreement that Justice Thomas will not be impeached and I assume won't resign. But do you think this is going to have any effect on him? And again, this is for all of you. Will this cause him to recuse more often or be less of an unabashed conservative?
I think if we've learned anything from Justice Thomas over the past 30 years, in fact 40 years, when he first came to Washington, he is unbowed. This will not affect him at all. I think I think it's obviously very hurtful to be attacking his spouse, and I think that's hurtful to him. But it won't, as he's demonstrated over the years, it's not going to have any effect on him.
So I agree with that completely, but I think it's an open question. So Justice Thomas has a titanium spine, steel spine. It's an open question whether his colleagues on the court or conservative judges on the lower courts looking and saying, well, whatever happened, I don't want that happening to me. Whether they will remain so steadfast and true remains to be seen.
Let me ask Russell. I think there's a perception among conservatives that intimidation by the left has been, somewhat successful, whether we're talking about Schumer or Senator Whitehouse or, Obama while the Obamacare case was being decided, that, at least in close calls, some of the conservative justices think twice about angering the left. You're, as someone who's not on the right, do you think that's been the case, or do you think that's exaggerated?
What's the question? Have justices, conservative justices, been attacked more than justices on left?
Yeah, I think conservatives view that intimidation by the left has had an effect on some of the conservative justices, may have even affected the Obamacare decision. Do you think there's truth to that? Or do you think it's exaggerated?
Well, I mean, I'm not close enough to the scene to really know, but I think the Obamacare decision, I think Chief Justice Roberts is concerned about the legitimacy of the court also. And I think that explains not only his behavior in part in the Obamacare decision, but his more recent decisions in which he has been siding with the three so-called liberals. Whether that's totally tactical or not, I don't know, but I think he is worried more than some of the other justices about the court's standing.
Now, he's often congratulated for considering the legitimacy of the court, but do you, in your view, Russell, is that in itself legitimate? Should justices just rule on, totally based on the law, or is it okay that they take into account things like the court's reputation?
Oh, I don't think there's any question they have to take both into account. It's called judicial statesmanship. No doubt in my mind.
I would consider it judicial abdication when they do that.
I mean, look at the case, the post-Civil War case involving the I can't remember the habeas case, and then the editor from Mississippi, where Congress tried to strip the court of the jurisdiction. The court said, "Okay, fine. I wasn't going to fight it then because I had such a black eye from the Dred Scott decision."
I agree that it happens. It's not easy, as we all know, to pass a law, and if the court engages in shenanigans of some sort to rewrite the law under the guise of interpreting it, they have done away with the decision that was really best left to our elected legislatures. And when it comes to the Constitution, until they reconsider or there's a constitutional amendment, they are the last word. And to have them again tilt our founding document, in order to please the current zeitgeist is an abdication of their, to my opinion, judicial oath of office.
Now, in the next few months, we'll have a decision in Dobbs, the Mississippi abortion case. If that comes out the way most people expect, which is either partially or completely overturning Roe and Casey, the left will no doubt be angry. Do you all think this is going to lead to a lot more of these back and forth charges of ethical or otherwise?
Certainly, and it certainly will, between the time the opinion is issued and the time of either the midterm election, or if the Republicans take control of the House or Senate, they're being invested in January. I don't know how the left will react, but if Roe and Casey are overturned, they will not react well.
Any other predictions?
If Roe is overturned, what's little is left of it, it won't be just the people on the left that will be upset. There'll be an awful lot of women will be upset also on all sides.
Not conservative women, but yes, I understand.
Yeah, well, it'll be interesting to see, and we will see in the next few months. We only got like a minute left, so let me circle back to something we've alluded to, which is basically updating, strengthening a judicial code of ethics for the Supreme Court. Do you think what's going on now with the Thomases, will that affect that debate? Will it cause changes to be adopted? And I ask that to all of you.
Well, there are discussions going on in the House now. The congressman from Georgia, whose name is escaping me.
Johnson.
Yeah, he's proposed Judicial Accountability Acts. I mean, there are bills floating around, and they might very well pass the House now. They've had hearings, and I think are planning hearings. I don't know whether anything is going to pass, at least until after Dobbs and some of the other decisions are issued.
Any thoughts?
As I said, I think the court should adopt its own code of conduct for a variety of reasons. Some no more than PR. Perhaps all the pressure for it to do so has led some of the justices, I don't know the inside, have said, well, we're not going to, don't want to appear to be bowing to pressure, but I think they could solve a lot of their problems if they just do that. And it's not going to affect Justice Thomas one way or the other. An advisory set of advisory aspirational statements worded very loosely as the current code is.
Well,
Yeah, I mean, I think 455 pretty much does that in the courts, that applies to the justices, and they have their statement of recusal policy, which I think pretty much works. I'm not sure, Russell spent a lot more time on this in terms of what more needs to be done in terms of kind of regulating the justices' conduct with respect to recusals. I think Congress could have hearings. I don't think anything would pass that would withstand any constitutional challenge in terms of regulating the Supreme Court in this regard. Just like the president, just like Congress, they're at the top of the heap, and some things, they're self-regulating on certain things, and I think that's what's going to happen with the Supreme Court with respect to regulating their conduct.
well, sadly, we've run out of time. I thought this was a very interesting debate. We didn't even have time for many questions because there was such interesting back and forth between our three panelists. And of course, the reason it was interesting is that we had three great guests. So I want to thank you all for making this a great debate. And many of these debates will continue in the coming months. I wish you all a good afternoon.
Thank you, Kurt. Good to be with you.
Thanks, Kurt.
Good to be with you, everybody.
Thanks again.